whether Article 62 and 63 are inherently same or distinct. If they are inherently same, they can be used interchangeably. Then we can interpret 62(1)(f) in view of 63(1)(h). But if they are distinct, then we cannot interpret these two. We cannot try to resolve the ambiguity. So I have to demonstrate that Article 62 is distinct than Article 63.
Is it not dependent? Article 62 is not dependent upon 63?
No, my lord. How do I demonstrate that? If I just go to Article 62, it says, a person shall not be qualified to be elected or chosen as a member of Majlis Shura unless it talks about an event prior to the election.
Yes.
Both are happening before the election has taken place.
Elected or chosen.
दोनों चीजें एक है, disqualified or qualified है, but it's synonymous. I mean, it makes no difference.
63 का जो second
तो फर्क क्या पड़ना है इस आर्गुमेंट से आपके? How will it support you?
So because if I can convince my lordships that they are two distinct sections because of their...
Because there are two distinct sections, but what will turn on it? ये बताएं ना.
Then we have to interpret 62(1)(f) only.
तो वही उसी पे तो आपको ले जा रहे हैं.
We do not have to interpret 62(1)(f) in view of 63(1)(h).
चलें 62(1)(f) को कर लेना फिर आप.
आपका आर्ग्यूमेंट ये है कि 62 and 63 are distinct articles and we cannot interchangeably read them to give them a meaning.
My lord.
So उनको separate पढ़ेंगे, उनको separate. We've understood your point.
आगे बढ़ें. थोड़ा सा स्पीड कर ले फिर. We don't want to leave this case unresolved.
10-15 more minutes. Now, when I distinguish that they are two distinct, then we have to read 62(1)(f) on its own. Every word has to be given its meaning.
चले थोड़ा जल्दी करें.
Mission is that when we will read 62, then as long as the declaration by a court of law is in field, disqualification will remain.
The court of law declaration is the Supreme Court itself. ये point पे आ जाइए ना.
Supreme Court itself cannot give in any other jurisdiction other than in its appellate jurisdiction.
हो गया ना. आपका फिर समीला बलोच वाला argument है ना कि once the declaration is there, 62(1)(f) has to be read alone. Once the declaration stands, disqualification stands.
My lord.
And it goes on as long as the disqualification. So the question to you is that we have to look at the Constitution in totality as a whole. Does it not appear odd to you that for other crimes as big as perhaps treason in G and others, you can always come back and contest election? It's not a lifetime situation. But for a civil wrong, which could be as small as committing a misdemeanor of misdeclaration or just lying through you've omitted one entry in a return, the punishment in a way is for life. But if I were to go murder somebody, if I would commit treason, if I were to kidnapping, I could come back and contest election. दोनों चीजें एक है.
The tribunal gets the powers for life time disqualification.
It has declared.
No, where from gets the powers to declare?
It has declared a decree given remains intact for all purposes. Now, this argument basically lies in Islamic principles. If you look at PPC, out of all those offences, there are very few offences in which mens rea is dishonesty. My submission is, wherever mens rea is dishonesty, we are talking about public office holder.
जो आपने you just very casually referred to Islam, either back it up because I completely disagree with you. You have to back it up. If your contention is agreed, there were those who were violently opposed to Islam, and then they became Khalifs, Khulfa Rashideen. तो वो आ ही नहीं सकते थे फिर वापस. This just don't throw in Islam just like that. It is contrary to Islamic injunctions. तौबा का प्रिंसिपल है, राय रास्त पे प्रिंसिपल वापस आने का प्रिंसिपल है, मुस्तकीम शारे मुस्तकीम पे वापस आने का प्रिंसिपल है. शुरू में तो 2-4 ही मुसलमान थे.
I mean, we are.
तो ये आप ऐसे just don't throw in Islam to give it a validity.
No, my lord. What I am submitting is, if repentance or tawbah, when we look at it,
repentance और तौबा की तो बात से आगे मैं चला गया हूँ.
That's what I am submitting. These are 3 things kept by God to Himself. Number 1,
Not at all.
Izzat Zillat.
Not at all.
Let me make my submission.
No, submission, you refer to the Holy Quran. You can't just make a submissions contrary to Islamic principles like this. ऐसे नहीं होगा.
But I change the subject a little. Let me just introduce one other aspect. Let's stay on 62(1)(f). If we look at 62, some of the disqualifications or qualifications are mentioned in the Constitution itself, like he has to be a citizen, the age and all. This is specifically provided. 62(1)(f) brings in a disqualification from a declaration from another court under some law, not the Constitution. It is a declaration of disqualification under declaration of contrary under some law. And if the law, Parliament goes ahead and fixes that law and says any such declaration of that law has to be for 5 years, that is actually not tampering with the Constitution. It is providing that any declaration in 62(1)(f) is arising out of a law, not of the Constitution. Because court of law ne karni hai na disqualification. That disqualification is arising out of a law, and the Parliament goes ahead and says any disqualification under the law has to be for 5 years. So then, with that 5 years amendment brought in, isn't the period being provided for 62(1)(f)? Because the Constitution itself doesn't give an unlimited period. It is relying on a declaration coming out of a law. And law has been corrected and given a period. So there's a distinction. Had there been a constitutional